What happens if you don't get an actual patent after the provisional? What if your one year is up? Does that mean your idea is public domain now?
Not necessarily, it depends on how you treated it. So at the 1 year mark, the provisional patent application expires. An issued United States patent will never issue from a provisional patent application, only from a non-provisional. So I kind of call it a placeholder. So you go to the patent office and you say, hey, hold my place, but I want today's date to be my placeholder, and dates are important in patent law. So, so at 1 year, if you don't file a non-provisional, it just expires. If you haven't disclosed it to anybody, it doesn't become public domain because it just sits at the patent office and it doesn't do anything. But if you have disclosed it, then once the provisional expires, you no longer have patent pending rights, and somebody else could take your invention and market it and sell it themselves. So the non-provisional, unless you're really having zero success and you have absolutely no money and you just can't take the next step, the non-provisional usually is the next step that our inventors take. But it's very beneficial for our startup companies and individual inventors.
To do the 1 year?
Yeah, and then follow up at the 1 year mark with the non-provisional. For bigger businesses, a lot of times if they've been doing this for a long time, they know that their invention is going to be successful, and they know that it works, and they know they're going to be able to market it, so they'll just go ahead and start with the non-provisional. So that's always an option. As patent attorneys, we much prefer writing the non-provisionals because there's a lot more work and it gets a little grittier, and it's just a lot more interesting for us. But the provisional is typically the best course for smaller businesses and startups.
Is it possible after the provisional to get denied for the non-provisional?
Yeah, it typically does get denied the first time. So you file a provisional, all it does is it sits at the patent office and just it's holding your date, today's date. And then at the 1 year mark, we file a non-provisional patent application, and then that gets examined by the patent office. And it usually does get rejected the first time, but then we make arguments and then they usually allow it.
And do you really have to have a meeting, like with yourself, to even know if your idea is patentable? It might be a new idea that's not out there.
Right.
But like a car, you would think that a car could have been patented years ago, but yet look at all the different varieties of vehicles that have 4 wheels with an engine, with axles.
Right, yeah, that would have been patented initially many, over 100 years ago.
Oh, okay.
So then any new advances would be, so for a car, at some point the intermittent windshield wiper was patented.
Right.
A different braking system would be patented. An improvement on a car's air conditioning system would be patented. So GM and Ford and Mercedes-Benz, for example, all of those companies had huge patent portfolios.
Right. But you could have an idea today that isn't patentable, but you could start a company with it.
You could,
Yeah.
There's a couple different things. There's patentable subject matter, and that just means that your invention or your idea falls within the categories that are patent eligible.
Right.
From there, that invention needs to be new. New is very easy. I mean,
Right.
you just change something very, something minimal. But it does need to be non-obvious. So in the world of air conditioners, something that improves the efficiency, reduces the electrical consumption, improves output, anything like that would be an improvement and would likely be considered non-obvious.
Mm-hmm.